Okay, let's, if we could all gather for our last event. First of all, I would like to know how the judge voted, or how he would have voted 5 years ago. It's a real pleasure to have Judge Michel with us today. The title of his talk is Patent Scope, Validity, and Infringement Matter, Not Who Acquired Ownership of the Patent, for All Owners Are Entitled to Be Asserters. The details of Judge Michel's distinguished career are well known, and some of them are in your materials. I will simply say that I first met Judge Michel 17 years ago, and even walking the hallways of the Federal Circuit back then, he has always been terribly gracious and kind, and he's equally so now. And more importantly, every time I spend more than a minute with him, I walk away more knowledgeable. It's one of these people where you always learn more. And so I have terribly selfish reasons for having him here too. So with that, I want to introduce the judge and say how much we look forward to your comments.
Thank you very much, everyone, for your interest, your being here. This is an amazingly rich audience because of the diversity that you represent: law firms, companies, academia, other institutions and players in the larger patent community. And of course, the panelists also had that same wonderful, rich diversity, which I thought was just great. I learned a lot this morning and found it extremely interesting, and I'll try to some extent build on what was presented, but also to go beyond that, to give you some thoughts of my own. The goal is really to further stimulate thought, because that's what's needed. These challenges are substantial. They aren't going away. They aren't decreasing. The solutions are not easy to design, and they won't be any easier to implement once designed. So there's an enormous amount of creative thinking needed from the patent community, particularly the private sector part of the patent community, which basically is all of us here, now including me, because now I'm a private citizen for 21 months for the first time in 44 years since graduating from law school. And in my new life, for these 21 months, I've done lots of consulting and a fair portion of pro bono speaking and meeting and lobbying and educating and so forth. And I've made one discovery which I would like to mention to you, because it's so relevant to who all of you are and where you work and what you do. And that is, I've been overwhelmingly impressed by the level and depth of talent everywhere I've gone. Think tanks, academic institutions, not only law schools, but I've been hanging out with engineering schools and business schools and university presidents and so on. Law firms, I've been working closely with law firms. I've spent a lot of time with clients on strategy planning, so I've learned all kinds of new things I never knew much about before, about the users of the system, the inventors, the manufacturers, and everyone else. And the astounding treasure that this country has in the brain power of the private patent community is huge and is much needed. As you'll see in my remarks, I've about given up on the public sector. Congress had a chance. It spent a decade following the work of the Federal Trade Commission and the National Research Council of the National Science Foundation, 2 big reports, 1 huge bill. 10 years later, are we vastly better off, or do we still have an awful lot of work to do? My conclusion is we're somewhat better off, but we have a ton of work still to do. The 2 questions that dominate all of my thinking, and I hope will be of interest to you and will be high on your list, if not necessarily the top 2, are number 1, global competitiveness. Can we continue to compete successfully with every rival country that designs and manufactures products and processes? To my perception, we've had a lot of slippage. There are a lot of countries that are doing way better than they were doing before vis-a-vis the United States. And if we don't get better traction, we may fall further behind. So that's the number one big challenge, is global competitiveness. The second issue or challenge that just dominates everything else in my view is the challenge of incentivizing adequate investment. And again, it goes back to this public sector, private sector divide. In the perfect world, some might argue, the incentive to fund research and development shouldn't be needed because the government would fund all the research and development that the country needed. But we're not there, and we're not going to be there. The level of federally funded research and development is very likely to stagnate. It actually already has stagnated. It's likely to go down on the defense side and the civilian side, and it's likely to go down appreciably in the future. So if we're going to have more innovation, more invention, more new products, more new prosperity, it's going to have to be funded from the private sector. The angel investors, the equity funds, the venture capitalists, the big banks, all the different financial players. And they aren't doing it now. They're sitting on trillions, untold amounts of money, and they're not investing it because they don't see the demand. That's sort of the hangover of the recession. But they also don't see the incentive, even if demand goes back to some higher level as it was before. And on top of that, we have the whole employment problem. This country needs to create, in the next 5.5 years, 28 million net new jobs. So stick with me about net new jobs, because you read in the paper about how GE opens a factory in Alabama, and they hire 4,000 workers, and isn't that great? But obviously, if they offshore 5,000 other jobs at the same time, the net new jobs are zero. So net new jobs are what counts, not just new jobs because of a new facility created somewhere. Whether we look at it from the standpoint of prosperity, from the standpoint of global competitiveness, from the standpoint of technological leadership, from the standpoint even of government solvency, if our private sector can't thrive, not only will individuals suffer, their families suffer, companies suffer, but so will every level of government, local government, state government, federal government, because their revenues will go down if the economic activity slackens. So then how are we going to rebuild the crumbling infrastructure if the available funds at all these levels of government goes down because our whole economic engine starts to sputter? So an awful lot at stake here. I want to say that I'm thrilled to be here. This is my second time appearing at the call of Craig Nard, who was a prized law clerk. One of the great fringe benefits about being a federal judge as a law clerk. It's a well-kept secret, but it's absolutely marvelous. Your own law clerks become this ever-expanding little extended family, little army of like nieces and nephews, and you get to know their spouses and their children and their parents, and it's absolutely wonderful. I've married several of my former law clerks who officiated at their wedding. So anyway, it's absolutely great. Now, it happens that Professor Nard was not one of my law clerks, but just really the point I'm trying to make is that for all of the judges of the Federal Circuit, and it's true of other courts as well, every colleague's law clerk sort of becomes a friend, an ally, somebody you care about. So when Craig Nard calls me up, I show up, and I'm thrilled to be here. This is my second time, as I said. Okay, NPEs. It was observed, I think quite accurately, that it's very difficult to define what is or isn't an NPE, and you get a lot of different opinions. Some people have tried to solve that problem linguistically by alternatives. So instead of non-practicing entity, that is some entity that doesn't manufacture a product or practice an invention, alternative labels, patent assertion entity, patent aggregators, etc. They suffer, in my view, from much the same problem, even if to a lesser degree. People can't agree on who's in and who's out, and even if you could agree on the content of that label, they're not all bad actors. So the real issue is, who are the bad actors, not does somebody fit this, that, or the other definition of an NPE, a patent aggregator, a patent asserter, et cetera. Beside, here we are in a great university, in a great city in the United States. So every university is an NPE. Does that make them evil? Does that mean they shouldn't be able to get patents or sell patents? Every great research institute in this country, it doesn't matter whether you talk about the Scripps Institute that's trying to come up with cures for cancer, or you talk about the Howard Hughes Medical Institute in Bethesda, Maryland, or any number of other great institutions that we have in this country that focus on research. They aren't trying to make things. That's not their profession. Their profession is to invent things. So they're NPEs. Are they evil? Do we want to crimp their future? I wouldn't think so. How about teams of inventors? The Jarvik heart, the first usable artificial heart, invented by a team of 12 people from cross-disciplinary team. They don't make anything. They never tried to make anything. They'll never make anything. So they, by definition, almost any definition, are NPEs. Do we want to discourage them? Do we want to make things hard for them? Do we want to make their efforts less valuable in our overall economy? And then, of course, individual inventors obviously don't make products. Comment was made earlier about when IBM, I think was the example, sues somebody or seeks a license on a patent that it's not practicing, maybe never practiced, or in any event isn't any longer practicing, well then IBM's an NPE. So the terminology starts to lead us into a wilderness. It seems to me obscures the real problem rather than helping it. And even the more refined labels, patent aggregators, I mean, you can talk about intellectual ventures, you can talk about Acacia, you can talk about others, but now we have RPX and Allied Trust, and we've got offensive and defensive aggregators, and so aggregators doesn't seem to me to be a terribly useful category either. So patent asserters, take Qualcomm. They invent a lot of stuff, they make a lot of stuff, but they also assert patents. So when they assert a patent for something they're not making, I guess they're an NPE. So I'm suggesting, I think my conclusion is that the whole terminology about NPEs and the synonyms, number one, isn't terribly helpful in the end, and number two may be sort of the hangover of the patent reform debates on Capitol Hill. It's a sort of a polemical term. Of course, the ugliest version of it is troll. I haven't used the T word yet, but we all know it. So that debate featured, as I'll detail a little bit later on, an enormous amount of propaganda, PR of the crassest sort. Editorials were written and placed in scores of papers all around the country over a decade-long period to try to influence the debate on Capitol Hill. Not to mention campaign contributions, not to mention bundlers, not to mention people from great companies, executives from great companies holding fundraisers in their homes for $20,000 a person, and on and on and on. So the sort of propagandistic hangover of some of the terminology, I think, is unfortunate. And in any event, I don't think it helps us to find the problem. So much was made of the fact that property has to be alienable, or it really isn't property. Now, some say, including my friend, the Cisco General Counsel, Mark Chandler, that, well, we've got the whole wrong frame of reference here. We have to redesign patent law because it really should be considered not a property right, but a contract right. Well, whatever the merits of that may be in some abstract sense, well, it's way too late for that. You know, we have 200 years of patent law in this country. It's a property right. So, you know, that just goes out the window. And of course, the right to exclude others from your property, whether it's the wristwatch Professor Duffy wants to sell to somebody, they can't take it. That's thievery, you know. If he wants to sell it, fine, but they don't have any right to have it unless he consents to them and their price. So the the right to exclude isn't peculiar to patent law. It's really, of course, the classic example is land. If you own a plot of land and I start farming on your land, you want to charge me rent. Of course, you should. And you don't have to be doing anything with your land. It can be a nature preserve, or you can build apartment buildings on it. It's up to you. You're the owner of the land. So the use with certain public safety, public health type exceptions, pretty much up to the owner. Same thing with the selling, and the right to exclude is part of that too. So my thesis is this. The problems in the patent system that are real, that we should worry about, that affect all these things, global competitive technological leadership, future prosperity, job creation, on and on and on, don't stem from who is the current owner of the patent. They stem from other sources. So my conclusion is that the problem is 70% in the patent office, 25% in the courts, and 5% with the NPEs. So there's some bad behavior in that space. I don't deny it. But it's not the main problem. And if we treat it as the main problem, we're going to miss the right solution because we won't be doing the right diagnosis. It's a little bit like medicine. If the diagnosis isn't correct and definitive, the treatment will not fit, and the disease will not get cured. The condition will not be ameliorated. So doing the right diagnosis is very, very important. Now, in the patent reform debate that I alluded to, one of the buzzwords, aside from NPEs and trolls, was poor quality patents. I spent 22 years, 2 months, 3 weeks, and 2 days on the Federal Circuit. I loved every day of it. I thought I would never give it up. It's a lifetime appointment, at least as the Constitution says, during good behavior, and apparently my behavior was okay. I wasn't being impeached. I could have stayed forever. I left. Why? Because I decided that what was going on outside the court in places like this, on sessions like today's, was actually even more important. That was what was going on inside the court, more important to the future of the country. As a sitting judge, I was not allowed to participate, with a narrow exception about the impact on the administration of justice, in any public policy, political, or legislative debates, such as surrounded what we now call the AIA. So I stepped down from the court near the end of my permissible time as chief. It's capped at 70, so I was coming pretty close to that ceiling anyway, and the patent reform debate was roiling in Congress, so I stepped down. I never looked back. I don't regret it as much as I loved every day there. Well, I feel like what I'm doing now is actually even more important than what I was doing before. So I spent a lot of time with patent examiners, patent board members, patent office high-level officials, and as I mentioned, people in the union movement, in industry, in think tanks, in academia, and everywhere else I could learn something. And as I said to Eric Spangenberg, if I had to go home last night, 4 hours after I got here, it would already have been worth it. Because John Wood teaches a class at this wonderful law school, which is a great, generous thing for him to do. He doesn't live here. He has to get here through snow and traffic and so on. So he asked Eric Spangenberg, Steve Oville, and me to come and participate in his class last night. And we did, and it was absolutely fabulous fun. The kids who study here, I'm 71, so I say kids, but obviously they're young adults. But the kids who study here are wonderful. They're very engaged, they're very smart, they're much more worldly and savvy than law students were 45 years ago when I was in law school. And we had a ton of fun. But we also learned a lot. I mean, Eric's in a world I don't know much about. I need to know more about it. He seems sort of interested in my world too. So we had a lot of useful exchanges. And Steve, a litigator of considerable experience, had yet another perspective, and John's from industry. So in a way, it was a microcosm of the kind of discussion we're having here in this room. It was rich because it was diverse. It was useful. Everybody was learning something. So anyhow, fortunately, it didn't end. I didn't have to get back on a plane last night and go back to Washington. And I'm very happy to have a chance to sort of give you some of my conclusions, not to try to convince you, but to try to stimulate you to think very hard about these problems. So I say 70% or so of the problems in the patent office. what does that mean? And what about this business about weak patents? Well, in all the time at the Federal Circuit, I never saw what I would call a low-quality patent or a bad patent or an inappropriate patent. I saw lots of individual claims in patents that were blatantly invalid or highly questionable or suspect under 112 written description requirement. But to talk about bad patents, weak patents, good patents, it's not any more constructive than talking about NPEs because it really masks the real problem. The real problem is, since it's a claim-based system, not a patent-based system, the Patent Office needs to be able to examine claim by claim, section by section. Is claim 1 okay under 101? Is it okay under 102? Is it okay under section 103, 112, and so forth? How about claim 2? That's how they have to do it if they're going to do it right. They don't even try to do that. They got 15 to 20 hours on average per patent. You can't even read the whole specification lots of times in that many hours, much less understand it, much less read all the prior art, much less parse every claim as against every statutory requirement. So there's a huge shortfall in what goes on in the Patent Office. So weak patent examination, problem number 1. But I don't absolve the courts because the courts, along with the patent system, the Patent Office, are where the main action or the definitive action occurs. So we have complaints that are filed that shouldn't be filed, just the way we have applications filed for claims, some of which shouldn't be allowed. So we have weak Patent Office examinations and re-examinations and appeals, but especially examinations. But we also have weak screens in the federal court. It's too easy to start a big lawsuit and impose a lot of costs on the other side. So that's a problem. Well, of course, we have notice pleading. So now you generate a lot of wheel spinning and inefficiency even inside the litigation. Forget about the larger ecosystem. We have excess discovery. So companies can spend thousands of man hours, millions of dollars just coming up with, every email worldwide that relates to a whole product line. It's completely nuts. As somebody mentioned, in Germany, there's essentially no discovery. England, of course, our heritage country, the legal system adopted with some modifications from England, they have about 5 to 10% of the scope of discovery that we have. So even a country that's not a continental country like Germany, but in our own tradition, doesn't have the kind of crazy discovery rules that we have. Why do we have them? I'll come back to that in a minute. We also have very weak screens to exclude inappropriate evidence. In my opinion, the Dahlberg case was sort of set off excludability of phony expert opinions in the wrong direction, at least from the standpoint of patent law. And it's kind of never recovered. So we're still stuck with inadequate ways to screen out evidence that shouldn't be in front of the court, much less in front of a lay jury. And then it goes on from there. We have a weak regime on claim construction with high reversal rates later. We have problems of excluding evidence on all the key issues, infringement, validity, damages, of course. I mean, some of the evidence that's allowed in damages cases is absolutely appalling. I mean, talk about junk science. I guess we would call it junk economics, but whatever you want to call it, it's a problem, and the law needs to be developed. I also think that our summary judgment practice, this, of course, blaming federal judges, is totally inadequate. There are lots of cases that should end at summary judgment that don't. A lot of people predicted when KSR came down that there would be lots of summary judgments of invalidity under 103. It didn't happen, and I think there's a lot of potential for that to be improved. District court litigations, too easily started, too long enduring, too disruptive, too costly, too slow, and too unpredictable. That's the worst sin of all, too unpredictable. Imagine being John Wood, and the CEO wants to know, what's the value of the patent if we sue? And what are my odds of winning? And of course, winning isn't unitary. It's not win-lose. It's, I've got to win on infringement, I've got to win on validity, there'll be 8 or 10 different grounds of invalidity thrown at me. So he's not making one odds judgment, he's making a dozen odds judgment that all then have to coalesce in some kind of final number. I don't know how he can do it. And this is a crazy system where it's that unpredictable. Even if you knew, even if the magic computer someday gives us a valuation regime that's really rigorous, and maybe it will. I'm a skeptic, but maybe it will. But even if you had an exactly precise number, could you do the odds right? The odds you're going to get past the invalidity challenges, the odds you're going to prove infringement, the odds you're going to get damages that would match what the computer says the patent should be valued at. Is a very bad problem. There's lack of predictability. And on top of that, lots of other things you know about. We have many, many needless bench trials on inequitable conduct that just harass patent prosecutors, often quite unjustly. There are cases of inequitable conduct. But if you look at the statistics, it's almost never found, it's almost always charged, and it's very frequently litigated through trial. That's a nutso system. Talk about inefficiency. So being able to screen those out, summary judgment, again, I think most inequitable conduct charges should be subject to summary judgment, but it doesn't seem to ever happen. So those are some of the problems in the patent office, in the courthouse. What are some of the solutions? Well, the Congress has given us as solutions all these new post-issuance proceedings in the patent office. So they continue ex parte re-exam, essentially unchanged. They substitute derivation proceedings for interference proceedings, but not a huge difference in terms of the burdens and the outcomes. But then they invent 4 totally new kinds of proceedings: post-grant review, inter partes review for financial type business method patents, and supplemental examination. So now let me get this straight. These are new assignments to the patent office that already is dysfunctional and can't do its job. Average delay time for an initial exam, 3 years. And if the technology is really important, it's much more likely to be 4 years, 5 years, 6 years. I've seen 7, 8, and 9 years, and in one case, 10 years duration for initial examination. Totally nuts. You want to lose the global competition, take 10 years or even 5 years to get a patent. That's a guaranteed way to lose out in global competition. So obviously what we need is vastly increased resources for the patent office. We need more examiners. We need better examiners. We need examiners who can be retained for a career, not leave after 3 years or 5 years to double or triple their salary the minute they cross the street into private enterprise. We need vastly upgraded IT systems. This is the IT agency of our government, and it has 20-year-old hardware and software. It's an absolute disgrace. Crazy. No wonder it doesn't work well. And they need lots of other things too. They need more board members. They need board members with litigation experience, because now the Patent Appeals Board is going to conduct something that will look almost exactly like a bench trial on validity in a district court. How much experience does anybody in the patent office, in the entire office of 10,000 people, have conducting invalidity trials? 0. Never done it even once before. Now they're going to have to do it all the time. Big challenge, very tough. Maybe they can mount it. They've got good people working on it, but it is a big mountain to climb. So they've got to be able to hire administrative patent judges out of law firms. How many of you want to have your salary cut in half? Interesting work, challenging work, important work, but huge financial sacrifice. So they've got to be able to pay better salaries to get qualified adjudicators for these validity trials. And they've got to be able to pay examiners better to bring them in, better to keep them, maybe some sort of bonus system to incentivize more rigorous and speedy work by examiners. And then, of course, we've got the courts trying to have a little more specialization, the pilot program, 14 districts, 44 judges in those 14 districts. That's a similar challenge in the sense that you've got to recruit the right people, you've got to give them support. How ironic is this? When Congress mandated The pilot program, its original architecture would give each such volunteer judge an additional law clerk with high technical training, right? So what did the Senate do? They took that part out, and they kept in the mandate to do the patent cases on this kind of concentrated basis, but without the help of the additional technically trained law clerk. Totally crazy. They took out the best part of the pilot program. I'll get back a little bit later to why that is. So what's hopeful? Hopeful is local rules in a lot of districts are, including this one, I believe, are coming into practice or have. That can help. That has a lot of potential as they evolve and get improved, get better understood. There's a lot of interesting training being done. Professor Mergis's colleagues at Berkeley for years have been training federal judges in basic patent law doctrines, and since then have produced, in conjunction with some very distinguished private litigators, a very good, practical, detailed manual to guide federal judges through patent trials. It's a very good piece of work. I had a little hand in vetting it, and I recommend it to everybody. The Federal Judicial Center is up to its eyeballs trying to help these 44 judges do it right, do it well, do it accurately, do it irreversibly. That'll help. There are a lot of hopeful signs in the courthouse and in the patent office with the great new leadership they have there, Director Capos, the top dozen officials. I know every one of them. I meet with them frequently. They're at a level of talent and commitment and energy and hard work unseen in the patent office probably ever, and certainly in generations. So a lot of hopeful signs, but a lot of problems. The main problem is the Congress, because in the very decade when the IT systems were becoming moribund, that's the word the director used in sworn testimony, moribund, and it's not an exaggeration, there was a plan, a roadmap of how to modernize the patent systems. It was first written in 2005, it was perfected in 2007. And every single year it had to be deferred in the implementation. Why? Because the Congress stole fee money, user fee money paid by the clients of many of you in this room. They stole it to the tune of almost $1 billion. So this is the agency that was sinking with IT systems breaking down more and more often, databases totally inadequate, bad hardware, bad software, and Congress was diverting private money, not taxpayer money, your money, when it was needed in the patent office. And then they took the technical law clerk out of the pilot program. So every time Congress could help, they end up doing something that's convenient to them, it looks like to me. I don't mean to sound too cynical, but it's a pretty disturbing picture, really. So the problem turns out to be reelection politics, because they are so starved for early money. It used to be you needed to raise money near the end of your term. Now you need to raise money at the beginning of your term, because almost everybody's in a one-party district. So the threat to your future, if you're a member of Congress, is to have a strong primary opponent. So how do you prevent having a strong primary opponent? You raise so much early money that nobody strong will run, because the odds are not good enough. So then you stay in Congress forever. So they chase money. When I was a staffer there, 9 years, 2 in the 70s and 7 in the 80s, the members of the Senate spent about 80% of their time solving problems of the country and working across party divides and ideological divides to make the country better. The other 20% of their time they spent trying to get PR and money. Now, they spend 80% of their time trying to get PR and money and 20% of their time, at most, trying to solve the problems of the country. So it's a very changed circumstance. And you saw this in the context of the patent reform debate. Tons of money was spent. There were 3,000 officially registered lobbyists lobbying on that bill. They spent hundreds of millions of dollars on lobbyists and PR firms, not to mention all the campaign contributions and bundling and all the other things that I mentioned. So kind of what happened was every big coalition that had lots of money behind it got most of what it wanted. Maybe not everything, but most of what it wanted. It was a kind of the net vector of all lobbying money. That's kind of what the bill was. It has some good stuff in it. I'm not against the bill. I think it's better they passed it than passed nothing. but it's got a lot of warts in it, and some of them are going to come back and harm us. I won't go through the history of the evolution because it shifted from year to year to year. If you look at the '05 bill versus, as many of you have, versus the bill that finally passed, there's not much resemblance. So where are we now? Well, we're now in what, in this country, we might call the post-Civil War period. We've had the big Civil War between California, IT, high-tech on the one hand, and pharma and traditional manufacturing and bio and a number of others on the other hand. And we have to knit it back together because the good of the country requires that we get patent law right. I think patent law, the patent system, it's not the only thing. I think it's the single most important thing for the future of this country, to get this system right, to get it working. And it will require people who used to be legislative enemies to find out how to work together, just like the two parties in Washington need to learn how to work together. So a lot of good seeds I see sprouting. There's something called the Sedona Group. Some of you may be familiar with it. A bunch of private practitioners, industry people, litigators that come up with sort of white papers on best practices and things like that, dealing with damages, dealing with discovery, dealing with how to help the pilot judges, as I like to call them. That's very constructive. I mentioned the work of the Berkeley Law School. Conferences like this have a very important role, in my opinion, are very hopeful. There are some university centers, not in law schools, that are beginning to get very interested in these issues. I think that has some great potential. I'm speaking at Princeton in May, for example, in a center that focuses on technology that's not based on the law school. Not that a law school base is a bad thing, but it's spreading. That's very hopeful. There are some think tanks that are in the process of forming that will have as their mission, and I'm involved in some of them, confronting these problems and trying to really wrestle them to the ground. So I see a lot of hopeful signs. Obviously, collaboration, cooperation is the key. And what's especially important, this goes back to incentivizing invention. If you look at some of the interesting reports of the last few years, there are two that stand out. They're not without controversy, but I think they're basically solid and correct. One by the Kauffman Foundation and one by the Census Bureau. These two studies essentially concluded that the most important player in the entire economic technical system in our country is a startup, which they define as a small or middle-sized company 5 years or less in age. You know, the future Apples, the future Hewletts, the future Googles, and so forth. It turns out, according to these studies, that almost all, now they say all, but I'm hedging because I don't think they have it quite, almost all net new jobs created in this country in the last 4 decades were created by startups. So if that's even close to right, then the patent system has to work, yes, for IBM, yes, for GE, yes, for Merck and all the other giants, multinational companies, we all know them, Fortune 100, 500, whatever. But it also has to work for other players, especially startups. And if you look at the evolution of the startups, it turns out they need outside funding, because of course they don't have a revenue stream. If you're IBM, you can do research based on your revenue stream. If you're a startup, you don't have a revenue stream, or at least not one that amounts to much. So you need outside financing. So you need the venture capitals, the equity fund people, and all the rest. So is the incentive going to be there to get them to put the money forth, first for the research and development, secondly for the scaling up where you build factories and hire workers, and third, for the initial public offering of stock, which turns out to be the biggest job booster of all 3 of those stages. But it costs money to do an IPO. So again, you have to get another huge dose of outside financing. If the incentives aren't there, you won't get it. You won't be able to tap into the capital markets of the country at large. So very important to get that system right. Some of you may remember the news stories, if you're old enough like me, or maybe you've read the book or seen the movie, Apollo 13. we're sort of in an Apollo 13 situation here. We have operators, that's the space vehicle crew, who have a huge problem. The operators are the patent office and the courts, the judges and the examiners and all the people that help them and work with them. Their systems are breaking down. It's not sustainable. And they can't solve the problem themselves. So you're Houston, all of you, academia, law firms, corporations, think tanks, wherever you are, you're Houston. You have to come up with a solution. Remember that scene in the movie? They got out about 150,000 different parts and scraps and duplicated the machinery on the space vehicle to figure out how to fix whatever the problem was. I don't even remember the exact problem. And they had people working day and night, really smart people, very motivated, very focused, because people were going to die if they couldn't fix the problem. And they fixed the problem in time, and the crew came back, and we all lived happily ever after. So we're at an Apollo moment. Now, Congress, in my view, is a spent force by and large. They did the best they could do under the circumstances, including all the ugly money influence that I mentioned before. They're pretty well done. They'll get back in the game to make some adjustment. They're pretty well done. In my opinion, they were pretty much clueless. They had very weak understanding of the whole IP ecosystem, patent law, investment, and all the rest. The courts are trying to do what they can do, but they're trapped, like the Patent Office, totally inadequate resources for more than a decade. We have 100 judicial vacancies, permanent state in this country. We have 100 too few district judges, 200 short. That's almost 30% under strength. If you want to fight a war, do you send an army that's 30% under strength to fight the war? It's totally crazy. So the courts need more judges. They actually have the money. This is the weirdest thing. The judicial budget has enough money for 200 more judges in it. But every single district judgeship has to be created explicitly by an act of Congress. And they won't do it because each party is holding out for when my side is back in the White House, and then we'll create the new judgeship. So they cancel each other out, so the new judgeships never get created. The last time a comprehensive judgeship bill, that is a bill that tries to rigorously match workload with workforce, the last time Congress passed a comprehensive judgeship bill in this country was 1991. So the systems are broken. It's just like Apollo 13. The courts are broken, the Patent Office is broken, the Congress created the problem. It needs to solve the problem to the extent that money is important. So the question is, what can the rest of us do? And I think the answer is, you are much more likely to come up with workable, targeted answers, because you know the problems way better than the Congress, their staff, anybody in the White House, or even anybody in the Patent and Trademark Office. You know, the PTO, in addition to all these new post-grant proceedings, had many additional burdens thrust on it by the AIA. It included 5 new complicated rules packages, which when written take up thousands of pages. They're just proposed now, and they'll be finalized later. They were mandated by the Congress to file 7 huge, difficult reports in which they were the lead agency, and 2 more in which they were to collaborate with FDA or some other lead agency, I forget who. Ton of new work, and it was really new. They've never done this before. They don't have any in-house staff to do this kind of report well. So lots of big burdens, and the reports are being written, I would say, by the wrong people. Who are the right people? All of you. You're Houston. You're the right people because you live with this system. You know the details, and the details are really, really important. So you can come up with better solutions than the Patent Office can, vastly better solutions than the Congress has, or I would venture ever will. So we've got to get away from the 5 to 10 year problem. 5 to 10 years to get a major patent out of the Patent Office, 5 to 10 years to get a major litigation through the court system. We got to get into the metric of 5 to 10 months instead of 5 to 10 years. So speed is a very big part of it. But accuracy is even more important. the reversal rate in patent cases is horrible. It's in the nature of 30%. The standard reversal rate in commercial litigation in the circuit courts in this country is about 15%. So in the patent field, the error rate measured that way is twice what it is on average. It doesn't prove everything, but it's a warning sign that there are a lot of things wrong in the court system, but especially in the patent office. Patents have to be properly examined and properly issued. And that is the best payoff if we can get that right. Accuracy is even more important than speed. I mentioned some of the things you need: several thousand more examiners, better training, better supervision. You know, it used to be most examiners were going to law school at night, so they knew something about patent law. They were learning patent law as they examined. Now they've abolished that program, another stupid fund-saving decision. They've abolished the program, so now almost none of the patent examiners are even law students, much less legally trained people. Terrible mistake. So we need more people who are legally trained. They need to be better supervised. They need to be better trained. They need to be better incentivized and motivated with bonuses and so forth. And they need office space. 1/3 of the examining corps doesn't work at the patent office because there is no office space for them. They have to work at home because the Congress hasn't provided the space just the way it hasn't provided the IT systems and the rest. So, not surprisingly, with bad IT systems, short office space, and 1/3 of the corps working at home. And of course, you can't let rookies or sophomores work at home. So who's working at home? The most experienced examiner. So if I'm a new examiner, what do I need? I need the guy in the office next door to be a highly experienced examiner that I can take all my problems to. But if he's working at home, it's much harder. Now, they're not all working at home. Not all experienced examiners are working at home, but a large portion of them are. So the whole thing is nuts any way you look at it. You may not know this, but one of the other little ugly secrets about how bad off the patent office is in terms of dysfunction is in Alexandria, Virginia, there is a warehouse. And when you file a paper patent application, it goes into this warehouse. And it is untouched by human hands and unread by any examiner for quite a while. Why? Because they found, and I assume they know what they're doing, that if an examiner, this is on average, it changes a little bit by technology, but if an examiner has a caseload of more than 90 active cases, it just becomes impossible. So a lot of applications are sitting in the warehouse until the examiner no longer has 90 cases, and then they get assigned to that examiner. Totally crazy, completely nuts. So we need to concentrate on solving the problem where it's worst. Patent office, secondarily the courts, and in a tertiary way, the practices of some NPEs. But those practices require litigation reforms. And I'll tell you another dirty secret. The problem with commercial litigation, especially patent litigation in the United States, is that it's overly dominated by judges. Judges. The Rules Committee that commands what the discovery system looks like is made up almost entirely of judges. They are psychologically biased in favor of the current system because it's their baby. They designed it, starting in 1938 with the federal rules and ever since. So they're loath to change anything on discovery, summary judgment practice, greater requirement of specificity in pleadings, and so forth. So part of the problem, and again why you're Houston, you're the solution, because many of you are litigators and others know a lot about litigation, is you could design fixes. And if you design them and industry, broadly speaking, will support them, they'll get instituted. Because the Congress can override the Rules Committee. The Congress can mandate federal rules, and they do, but only once in a great while. If you leave it to the judges, none of these problems will get solved. I hate to admit that, because I was one of them, and I liked and respected them. They're very smart, dedicated people. But they are really stuck in the status quo, and that's the worst place for America to be stuck right now in terms of our litigation system. So we can hope that the new post-grant review proceedings will really be fast. I doubt it. In fact, there was a little bit of false advertising used here. It was said, oh, don't worry, it's going to be 1 year. But the 1 year isn't enforceable. And it's extendable to 18 months, pretty much at will by the PTO. And it doesn't count the 6 months upfront petition stage. So it really isn't 1 year, it's 2 years. But actually it's not 2 years because that doesn't count the inevitable Federal Circuit appeal, which will yet add another year. So we're talking about a minimum of 3 years, not 1 year. So is it going to be faster than district court litigation? Probably somewhat, but not a whole heck of a lot. I think it will be considerably cheaper. It won't be cheap. It won't be as inexpensive as it probably should be. But it will be cheaper than a full dress invalidity trial. So in that sense, maybe we'll get some good effects out of it. So here's the challenge. When the Congress and even the Federal Trade Commission and the National Academy of Science assessed and studied patent law and what's wrong with patent law and how to fix it, there were almost no metrics, almost no quantification, almost no careful predictions. There was no ability to do a cost-benefit analysis because there was no calibration of either the costs or the benefits. It was all done on faith. So our country, through our Congress, took a huge gamble that this new bill will work really well. And maybe it will, maybe it won't. I think in some ways it will, in some ways it won't. What will the net be? Well, time will tell. So what's needed? What's needed is the missing kind of analysis that the Congress didn't bother to do, nor the Trade Commission, nor the National Academy of Sciences. So the motto has got to be count and measure, assess and evaluate, adjust and prescribe. That's what's needed, and it's going to have to come from the private sector because the public sector has exhausted itself trying and came up way short. Now, as I said when I started out, the biggest surprise to me, having been in public service right out of law school until I retired, so-called retired, I'm busier than ever, but I'm having a lot of fun. When I retired from the court and discovered the extraordinary level of talent in the private sector, it's given me huge new hope and confidence. We can get patent law right. We can have a good IP ecosystem in this country. We can have startups that will flourish like crazy and get the financial support that they need. But we don't have it now, and we aren't going to get it unless we make some substantial changes. So I suggest to you that you, the patent community, and now I'm part of it, we all have a very big job. We need to rescue the United States patent system. So the question is, will you help?
Thank you, Judge Michel, so much. We have time for some questions.
I spent 22 years asking questions. Now's your chance.
Judge Michel, you mentioned that the patent office is broken, it's very slow, and that would require an increase in fees. Now, just off the top of my head, I have a proposal to see what you think of. Instead of examining all dependent claims during the examination process, do you think it would be worthwhile just that they examine the independent claims so they save time by not going through the examination? Because in my practical experience, they do a very poor job of examining dependent claims.
Well, number one, I don't really know. Number two, I doubt that that's a workable solution. Because then what happens to the presumption of validity? Are the dependent claims not presumed to be valid? I mean, there are a whole series of complications. I think the answer is a simple answer. Give the patent office the office space they need. Give them the IT systems they need. raise the salaries so that they can get better examiners and retain them for a career. In the European Patent Office, the German Patent Office, other places around the globe, it's a high prestige, high paid, lifetime job. We have the opposite here because the salaries are simply not adequate. We can change that. That's the way to fix it. Get the right examiners, support them, give them the equipment they need, let them examine all claims, well, not in 15 hours, but in 50 hours or 1,500 or whatever it takes.
Maybe it's not new, but has the Federal Circuit become more political? I mean, it seems to me that I can tell the outcome of the case depending on who the panel is. Is that always been the case and I just am starting to realize it, or is that a new development, or am I just imagining it?
Well, I think that Federal Circuit appointments are very important in several respects. First of all, since the most important cases for national impact are the patent cases, there are other important cases too, but as a group, it's very important for the court at any given time to have a strong core of lifetime patent people. And it has had for most of its existence, but that's starting to slip. So my hope is that in the next couple of years, when I expect there'll be 3 or 4 more vacancies, that most of them will be filled with lifetime patent lawyers, so that that needed core will be restored. Secondly, it needs to have balance, and I think that it has gotten a little bit out of balance in terms of, it's too crude, but pro-patent people and patent skeptics, and I think that is a problem. I don't quite agree about panel membership dependency. I think in maybe 5% of the cases, who the panel is has a big influence, but not in the vast, vast majority of cases. But it's just like making sure you, the private sector, the users of the system, making sure that the patent office has what it needs. We all need to also try to make sure the Federal Circuit has what it needs. First of all, I told you I'm 21 months out of office. I gave them 6 months advance warning, and my seat still hasn't been filled. So it's over 2 years. So this is crazy. It causes more delay and more risk of error, more risk of errant decisions. So the quality, the impartiality, and the background of future appointees are very, very, very important. And the patent community should really ride herd on that, should lean on the Senate Judiciary Committee that has a big hand in this, and on the White House to appoint well-qualified people who are not excessively pro-patent or excessively anti-patent, but have some kind of a balanced view. I think it's entirely legitimate for the patent community to participate strongly in judicial selections and in suggesting people for judicial selection. And I hope you will. I think it could make a very big difference. And I think the Federal Circuit needs to have a sort of a mind change in this respect. It's 30 years down the road now. We've decided every type of patent issue many, many, many times, thousands of precedents. So to the extent that external circumstances or the actual impact of cases, the unintended consequences, if you will, require adjustment, the court is trapped by its own process, its own precedents, because it can only change a prior precedent by going in bank, and it only does that very rarely. So the big change in attitude needed at the court is to go in bank much more frequently in order to be able to engineer adjustments that I would say are definitely needed, that we know from experience what didn't work well. So that's a whole other thing. And again, the patent community can stimulate that through amicus briefs and spotting cases that will elevate these issues and try to get them reconsidered in bank. I decided several thousand cases, voted on several thousand cases in my time. I only have one really, really big regret in terms of a decision that I voted for that I now think was totally wrong, and that's the Cyborg case on saying that claim construction is totally a matter of law, has no factual content at all, and should be decided de novo by a panel of 3 Federal Circuit judges, no matter what the district judge has done. I think it's completely nuts. I hope they revisit that. I tried in my waning days to get them to revisit. I could often get 4, 5, or 6 votes to go in bank. But when we had all 12 judges, you needed 7. It takes a majority to go in bank. The Supreme Court, a minority, 4 out of 9 take up a case. But in the circuit courts, you need a majority, 7 out of 12, 6 out of 11. It's hard to get. It shouldn't be that hard, and the bar and the community should push the court to go in bank more readily and to do it when it's needed. Very good question. Last question, last clear chance. Thanks for being such a good audience. It was great fun to be. Professor Duffy, he gets the last word. Sure.
Okay.
Until Craig shuts us down, I'm here.
Okay. So in your talk, you mentioned early on, you said that that you'd seen bad claims, but not necessarily bad patents. And the Federal Circuit, throughout its history, has really pushed the patent system in a very decided way towards a claim-based system, much more so than it was before. And the theory was that it would create certainty. And now you see patents like the the NPT patents, the ones that were asserted against BlackBerry. You know, just one of those patents had 700 and some odd claims, 784 claims. And that to me, you know, is a question about whether that's really more certain than a small number of claims. Like, for example, I was reading the Edison patent just the other day, because that's what we do as professors. And it had 4 claims. It had 4 claims in it. And I think the inventors could write that number of small claims because they thought that they would be interpreted really to get at the heart of the invention. And indeed, the Supreme Court always said that you should interpret the patent claim to really get to the patent, to the invention. And the Federal Circuit now says explicitly that is the last step that we only use as a tiebreaker, if we ever use it. And I wonder if there's any second thoughts about that project on the Federal Circuit about pushing this into a claim-based system. Because I don't think that it would have been described as a claim-based system in 1982 as much as it is today.
Wow, that's a lot of questions.
It's my job.
I don't think that the emphasis on claims as defining the scope of protection is the road to hell. I think 700 claim patents is the road to hell. You mentioned earlier, and I thought quite sagely, that lawyers, whether they're in the role of a patent prosecutor or an infringement litigator, are in our system are required to be, or at the very least incentivized and encouraged to be, zealous. And that means that lawyers, usually for both sides, will be highly prone to overreaching. And so that means that judges or patent office officials have to be willing to put limits on that, put brakes on that, say, no, we're just not going to let you do that. And I think that both the courts and the patent office officials from top to bottom have been very lax, and that they should put limits on the number of claims. And in terms of judges, they've got to limit discovery. They've got to stop abuses. They've got to shift costs when it's appropriate. And they aren't doing it nearly as often as they need to. And they are rightly criticized for that deficiency. Beyond that, I think to some extent, and this goes back to my Civil War imagery, we need to have a peace treaty between the patent procurers and others in the system, where people agree we're not going to file 700 claim applications. The patent office has to put some brakes on it, but so does the community. It's going to take a kind of a, that's why I call it a peace treaty. We're not on the same side. We aren't trying to help the other people, but we don't like mutual assured destruction either, because that means everybody gets destroyed in the end. So we have to have some accommodation of the realities that everybody faces, whether it's the applicant or the people who are the potential defendants, or it's the patent office, or it's the people in the courthouse. I don't see any reason why we can't work that out as a community. Yes, sir.
On the number of claims, years ago, I was a full examiner, we had the rejection called undue multiplicity, and it was destroyed by the courts. Are you saying we should think about resurrecting that kind of a system?
Well,
700 claims is crazy.
look, the most important thing I learned about judging is it's all about imposing limits of every imaginable kind. So, of course, you should be able to limit the number of claims. And if claims are unduly repetitive or overlapping, that can be impeded by the Patent Office and by the courts, and I'd be in favor of it. Look, we have an out-of-control system now that's taking our country down. We need to fix it. We can fix it. It's Apollo 13. Thanks very much.